All right, I've now started the hearing for the public deliberation in the matter of CBA 19-481. This case comes to us by way of remand from the Circuit Court from Baltimore County from, I believe, a July 1, 2021 brief order. In background for the case, this was a requested variance for the standard that assisted living facilities in certain zones must be 1,000 feet from an existing facility pursuant to section 432.A.A1.A subsection 3, I believe. Um, the circuit court order was not appealed, so therefore we are basically dealing with that as the last word as our instructions on that case. The instructions from that order say we are to investigate in some capacity whether the facility at 2010 Northland Road is in fact licensed and in compliance with standards, or by definition, a facility that would prohibit another facility at 2100. The burning question for us would be, it was clear that this issue was never raised before the ALJ. It was never raised before us. And the reason being is that it is a variance request. And when you request a variance, you are conceding that you are varying from the agreed standard. So that would not be something that we address in a hearing for a variance relief. For the record, our decision was based on Cromwell v. Ward. We looked at the issues of uniqueness and found it wanting in that regard. But pursuant to the circuit court order, since it is not part of a variance request to determine whether or not there needs to be a variance, I believe the place where that decision is made is at the catalyst of the case back with the zoning office. So it is my suggestion that we remand by letter from this board to the zoning office who deals with the original applications for such a facility to give us an advisory opinion as to whether the facility at, I guess, 21, was it 2010, if that facility is licensed and prohibits one being at 2100. The end game being if they say, no, that place is not licensed or is no longer there would no longer be a need for a variance. This board would no longer have jurisdiction of the matter, and we would just dismiss it as moot. If they find that, in fact, the other facility is properly licensed and in keeping with the law, that information will be sent back to us. We will convene another deliberation, I guess, to make our decision in light of that based on the circuit court's instructions. So that's how I see it in my intention or suggestion, how we try to rectify this conundrum. I will ask my colleagues if they have any problems with that or have an alternative theory. Mr. Evans, your thoughts on the matter, sir?
That sounds like a reasonable resolution to me, right? I mean, we're dealing with a situation where kind of, well, it's the process is a little skewed at this point. But I think that what you suggest untangles the various issues and would be the appropriate way to go.
Mr. Pennington, sir?
I agree as well, Mr. Chairman. I think that what you suggested is probably the best route to go in this case.
All right, so what I intend to do is that with the help of our administrative staff, I will draft correspondence attaching our opinion and also the circuit court opinion, asking for the question to be answered by zoning as to the status of this other facility. Basically, we will stay any further proceedings as to this until that information has been provided. Again, if they provide information that that facility is no longer there or is not properly licensed, then at that point in time, I guess there would be no need for a variance. And we'll go from there. There being any other housekeeping matters before we proceed, gentlemen?
Not for me.
All
Nope.
right. All right, well, that's what we shall do. And I'm going to stop the recording and we'll see how it goes from there. I'll see you gentlemen in the next one at 9:30, I believe.
Yes,
10:30,
sir.
right.
See you then.
Thank you.
All right, bye-bye.
Appreciate it. Bye-bye.